Antes de darmos início ao evento, gostaríamos de reforçar o seguinte disclaimer. As manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participam dos eventos e transmissões online representam exclusivamente as opiniões dos seus autores e não refletem, necessariamente, a posição institucional da FGV. Após este vídeo de aviso, solicitamos a autorização para o uso da imagem e da voz dos palestrantes mediante manifestações de concordância, tais como um aceno de cabeça ou outro gesto de aprovação. Agradecemos sua participação e desejamos um excelente evento.
Good morning, good afternoon. I'm Justice Antonio Herman Benjamin, Chief Justice of the National Judicial Court of Brazil, or the National High Court of Brazil. And it's my pleasure to open one more event of the Consortium of Law Schools of Brazil and China that was established when we hosted at the court the first Brazil-China Law Congress. This event has a very important topic: artificial intelligence and legal teaching, the future of legal teaching. I believe it's a little bit improper to talk about the future because it is about the present. And this is quite important that we understand that we are not discussing something that we envision for the future. It's happening as we speak. It's happening in law teaching, but it's happening also in the way the judicial system operates. Courts around the world are using artificial intelligence and generative artificial intelligence, which is even more relevant for this discussion. I would like to thank the Getúlio Vargas Foundation for hosting us today. But as you know, this is a consortium of different law schools, and I see founding members of the consortium here with us today, Professor Lee, Professor Shi, and other colleagues that have joined. I am looking forward to the next event. I hope you have already selected the topic. It will probably be in the first few months of next year, since we are at the end of the year, unless you have other ideas. And of course, my court, the National High Court of Brazil, is always ready to assist with this work. We understand that Brazil and China have a lot to discuss, to share, and to learn from each other in all areas of science, but also in respect to the way we modernize our legal systems and the judicial system. Many thanks. Who is next? I think the deans.
I think it's Professor Shi.
Oh, okay. Oh, dear Chief Justice, I'm really glad we are meeting again, even it's online this time. Honestly, it is so important for us to keep in regular touch, and that's all thanks to Mr. Chief Justice's long-term vision and your down-to-earth work to make this happen. Thank you so much for that. It has been long. It hasn't been long since we last meeting, but AI technology has already made some big breakthroughs, and both China and Brazil have been some new cases lately. Things like copyright dispute over AI generated content, fraud involving deepfake tech, personal information protection issues, and new types of disputes such as algorithmic discrimination and algorithmic collusion. Even in Brazil's food delivery market, two Chinese delivery companies have been competing fiercely, and the lawsuit from that seemed to be in the second instance stage already. Actually, the food delivery business model is basically built on mobile internet. It's a location-based service, and the whole industry relies on algorithms to run efficiently. To put simply, AI with data, algorithms, and computing power at its core is now empowering economic and social development more effectively. It also boosting progress in the rules of law and legal studies, but at the same time, it posing challenges to traditional legal education. We have also noticed that many countries around the world are actively talking about how to reform legal education in the AI era. That's why today's meeting is so timely and the topic are so crucial. Reforming legal education is a systematic effort, and I think today's meeting is just the start of these discussions. But here's the thing: all the experts here today are actually practitioners of legal education reform. They are definitely be able to share their valuable experience and unique insights with us, helping us to broaden our perspective on the reform and expand the scope of our work to push it forward. Actually, so I'm really look forward to everyone's shares at West again. Thank you to our experts from Brazil and China. Thank you.
Good morning and good night at the same time for all the participants on this second webinar of the Brazil-China Consortium of Universities. It is wonderful to be here. We had a very important discussion in the first webinar on issues related to climate and now and international trade. And now we are moving back to artificial intelligence. That was a key topic on our presidential conference in Brasilia. I think this is of amazing importance, as both Justice Antonio Herman Benjamin said and Professor Shi. It has having an immense impact on the legal profession, on the implementation and law enforcement in most countries. And obviously, it's put a lot of challenges to legal education and legal research. that is already being impacted by the immense potential of artificial intelligence. So I wish good luck to all the participants, and we as deans will be following very closely your advice, because we have to take measures given what the researchers are doing at this moment. So it's wonderful, and I hope we can get into the end of this conference with an agenda for the next presidential conference that will be taking place in China very soon. Thank you.
Giovanna, we need guidance. Who is next? Please, you and Beatrice take the lead.
Professor Oscar Vera. I think there are two sections. May I make some suggestions?
Yeah, I
So
think
there are two
now
sections.
it's Professor Lee, and I'll ask him to take the lead from now on.
Okay, thank you. Thank you, Chief Justice Benjamin, and dear guest. First of all, I'd like to express gratitude to all of you, and sorry for my late access to the internet. I face problem for login. I think my colleagues also face a problem for login, which I think is more than 5 or 10 minutes so we can access on that. Sorry for that. Anyway, I think today's lecture is very important, and according to the agenda, Professor Oscar Vera and me are the moderator. May I suggest that for the first session, Professor Oscar Vera, you are presiding the first session, and then I will preside the second session. Is that okay? Yes,
yes, obviously, yes.
Okay.
Yes.
I'd like to explain a little bit that Professor Zhang Jiyu, we originally invited her to give the lecture, but she's visiting United States, so she cannot attend the discussion. But she presented her video last night very late to me, so I think she can, according to the schedule, she can use the lecture video, and then for discussion, I may discuss in the first session, and then the next session I will be preside. Thank you. So the floor is yours, Professor Oscar Vera. Thank you.
Yes. Vera, are you there? Okay. So I think we should move directly to the first presentation, and from what I understood, it will be through a video. So please, I don't know who's controlling, if it's Giovanna, that the video could be played.
Dear professors and colleagues, I'm Zhang Jiyu from Renmin University of China. I'm very glad and honored to be able to attend this conference, but I'm very sorry that because of the conflict of the schedule, I need to do a recording to do the presentation. So my topic today is to introduce the recent practice of Renmin Law School in recent years as an example of the exploration of rule of law talent cultivation in the age of AI. So AI technology has brought a lot of challenges as well as opportunities to us in the field of legal education. So we think at Renmin Law School it's very important to provide courses to students to provide better education for them to understand the AI technology and also the large models. based on those kind of knowledge, they can learn better how to do AI regulation.
Oops. I think we interrupt the video. From what I am reading on the chat, there is a problem of with the video that goes only for 1 minute and then it stops. I think our technical personnel are trying to solve the issue. So perhaps we should invert the order of the speakers so we can try to correct this fault. So is the second speaker for this panel ready to move on? Let's check here.
Hello.
Yes.
Earlier, due to the network issue, I couldn't hear the host arrangement for a while. I thought my earlier presentation was part of an opening session. Now I'd like to request to speak during the presentation session.
Yeah.
Okay, thank you. Distinguished experts and colleagues, good day. It's a real honor to follow up on the opening remarks and talk with everyone about the dilemmas and exploration in curriculum reform facing China's law school in AI era. We are truly studying at a crossroads with curricula right now. On one side, there's a solid foundation of traditional law courses. On the other, there are new demands we must address among the at the Asia view. Next, I will share some genuine thoughts based on the China's actual situation. Focusing on two suspects, what the challenges are and how we can fix them. Let's start with the first core issue. What's so hard about solving AR and related subjects into the already packed curriculum? This is not just about adding one more course. Every challenge Chinese law school face is pretty concrete. First, at most, prominently, there's a problem that faculty cannot keep up. Many of our law school teachers are trained in traditional law. They have a rock-solid grasp of civil law, criminal law, and procedural law. But when it comes to the AI technical principle or algorithms logic, a lot of them feel intimidated. Last year, I visited a local law school for research, and a professor who teaches intellectual property law said, now, to teach copyright for AI-generated content, I have to plow through half of a month of worse technical materials first, and I still worry about making mistakes. I wanted to collaborated with a professor from computer science department to teach courses together. But because the two departments have different assessment criteria, they don't have the broad ways to work with me. This is not the isolated case. Right now, there are still very few interdisciplinary teachers across the country who understand both law and AI. What's more, many institutions' faculty training system haven't yet incorporated AI-related skills into regular training. So teachers don't have many channels to improve in this area. The second, there are a dilemma of not being able to sequence in new courses. China's law schools already have a well-established undergraduate curriculum system from jurisprudence and constitutional law to various developmental laws, plus internship and thesis work. The class hour are already fully booked. If we forcefully and courses like AI and law or data compliance, we either have to cut hours from traditional core courses or make students put in extra hours. A dean of academic affairs at one law school complained to me last year. We wanted to add an elective called algorithm supervision, but students hesitated to sign up. They were afraid that if they take this course, they wouldn't have time to review key courses like civil law and criminal law, which are essential for postgraduate entrance exam. We also face the issues of curriculum syllabi lagging behind. AI technology updates quickly. Algorithm complaints points we teach today might become outdated in 6 months due to new regulations, and we have to revise the course content accordingly. But adjusting syllabi requires going through procedures which often can't keep up with the pace of the change. There are another easily overlooked challenges struggling to prioritize. Chinese universities place great emphasis on indicators like discipline, evaluation, and employment rates. Evaluation for traditional law disciplines rely on core journal publications and bar exam pass rates, but AI and law is interdisciplinary fields. It's harder to publish papers, and in the short term, there are no obvious direct boosts to employment rates. So some institutions think instead of investing efforts in AI courses, we should first solidify the foundations of traditional law. Even friends from a practical sector told me when their law firms hire new graduates, they still first look at their grasp of criminal law and civil law. As for the AI-related skills, they think it's fine to learn them after joining the firm. When this mindset spread, institutions actually naturally lose innovation to push forward with AI courses. So, in the faces of these challenges, how should China's law schools rethink their curricula to ensure students understand the technology and can address the ethical and societal issues of AI? Over the past 2 years, many institutions have been figuring things out. through trial and error. And there are few approaches I think are worth learning from. First, avoid a one-size-fits-all approach to addressing causes. Take an incorrect route. We don't have to offer so that alone AI and law course. Instead, we can break down AI content into existing courses. For example, when teaching civil law, add sanction or copyright ownership of AI-generated content, and use the civil subjects provisions in China's civil code to analyze whether AI can be considered not an author. When teaching administrative law, discusses administrative supervision of algorithmic discrimination, using effective judgments from courts to help students understand the administrative responsibility behind algorithms. China University of Political Science and Law tried this last year. They added a chapter on the rules for authenticating AI evidence to their civil procedure law courses. Students feedback. It doesn't feel like an extra burden. Instead, it lets us apply traditional legal knowledge to new scenarios. This approach doesn't crowd out core courses, and it helps AI content it take root. Second, teach technical skills and ethical education hand in hand, doesn't neglect one for the other. We can't just teach students how to read algorithms reports. We need to make them think about how to use algorithms fairly. For example, we can offer a special course on AI legal ethics using China's personal information protection law as a blueprint to analyze the boundary of facial recognition technology in judicial proceedings, where we not only teach how to achieve facial information digitization technically, but also discuss what to do if digitization is incomplete and infringe on the party's right to privacy. Last year, we held AI legal training camp where students stimulated handling cases generated by spreading rumors. On one hand, they had to research how to trace the source of the AI generated content from a technical perspective. On the other, they discussed how much ethical responsibility platform should bear. Finally, they even had to write a complaints recommendation. Students said this training helped them realize AI is not just a tool, it's a tool that needs to be boxed in by law and ethics. Third, bring the political sectors to co-build courses. Don't teach behind the closed doors. Legal issues related to AI can't be fully addressed just by discussing them in classroom. Students need exposure to real-world scenarios. For example, we can invite in-house lawyers from internet companies to teach practical algorithm compliance, invite judges to explain judicial reasoning in AI-related cases, or even send students to intern in the legal departments of AI companies to help review algorithm services contract. Last year, Alibaba legal department collaborated with the several law schools to launch a practical data law course where students directly participated in stimulating compliance review for cross-border user data transfer. Students feedback afterwards. We used to think algorithms compliance was on theory and no practice, but now we realize it requires balancing technical feasibility, legal regulation, and user rights. It's much more complex than what in the textbooks. This kind of university enterprises collaboration not only fills the gap in actual expertise, but also helps students to adapt to practical needs in advance. Finally, I want to say there is no one-size-fits-all answer to law school curriculum reform. AI technology is still evolving, and our legal system is also improving. For example, the newly revised cyber securities law this year and provisions on algorithms security in China. Curriculum must adjust dynamically too. But one thing is certain, we are not training lawyers who only memorize legal provisions. We are training digital rule of law professionals who can uphold legal bottom lines and safeguard social justice in AI era. These challenges and the exploration we have discussed today are just the beginning. Moving forward, we still need all of your experts to brainstorm ideas together and make the parts of the curriculum reform more stably. That's all from my series. Thank you all.
Thank you. I don't think we have the video already. I think there was a. Please, Beatrice, if you could tell us. Professor Lee, do you have your hands?
Yes.
Yeah.
Can I share the video to see if it can
Please.
work or not? Okay.
Let's do it. Let's do it.
Let me do it. Is that okay?
Yes.
Okay.
I think the sound is very low. If you could.
Able to attend this conference, but I'm very sorry that because of the conflict of the schedule, I need to do a recording to do the presentation. So my topic today is to introduce the recent practice of the law school in recent years as an example of the
Yes.
of rule of law talent cultivation in the age of AI. So AI technology has brought a lot of challenges as well as opportunities to us in the field of.
I think if you could put louder would help.
Let me try.
So it's very important to provide courses to students to provide better education for them to understand the AI technology and also the large models. Based on those kind of knowledge, they can learn better how to do AI regulation, AI governance, and also they will know better how to use AI to support their studies as well as researches in the field of rule of law. Also, we hope that in the future they will be able to create more new AI technologies by themselves in cooperation with, for example, some students from the IT technology. So we think it's very important to let the students to have both a very well knowledge in the field of law, as well as to have basic and necessary understandings of the AI technologies. Also, humanity education is more important today because we want AI to really benefit ourselves to bring beneficial to the whole society. And also because in this society, we have witnessed fast development of technologies and business models and so on. So we think for every student, they will learn better how to do lifelong learning by themselves.
Professor Lee, I think it's working fine now. Just
Okay.
hire our computers and it's working fine.
Okay.
To undergraduate
Thank you.
Thank you.
master students as well as doctoral students. So for the undergraduate students, we provide a honors minor degree in digital law, and for the master programs, we have both Juris Master program in digital law as well as the M in digital law. Also, we have been providing a program in Chinese law at Generative Law School. So the courses in the program are all given in English. We also have a course, digital law in China in English for the LM students in Chinese law. And also for the doctor program, we have provided Doctor of Law, similar to the JFE, in digital law, as well as the Juris Doctor program in digital law and IP law. Here are the main courses of the digital law programs. We can see that we have two main camps. One is the digital law courses group, and the other is the legal technology courses group. So from the digital law courses group, we have the introduction to digital law, civil law, personal information protection law, data law, AI law, and so on. And also for the legal technology courses group, we have both introduction to AI at the university level for the students who are not majored in EBCS. And also at the law school, we provided some courses by ourselves, and also there's a cooperation with teachers, professors at the AI school. So we have provided introduction to Python as the programming languages for law students, and also computer representation of legal rules, legal data analysis basics and practice, and also the big data and digital courts. So those are the main two cans of the courses we provided to the students. We have also some other kinds of courses. One is the so-called two teachers in one course. In those kind of courses, we will invite, for example, the judges from the Beijing Internet course, and also the lawyers, both the lawyers from law schools, from the law firms, and also the lawyers in course of the big IP technology IP companies. So they will, along with the professors at our law school, together to provide some both theoretical and practical courses to the students. And also we have a special kind of courses. They are called the innovation and research course. For those kind of courses, students can bring up the issues they would like to study or do research, and we will assign the right professors to give them some guidance to their research. So those kind of a new course, new type of courses in the university. And students have designed and the researchers by themselves in the course and also outside of the course. For example, we see that some students have done some developed search algorithms based on deep learning and so on. So those are some examples of their projects. And also they have designed some projects to do some experiments on the effect of generative AI, for example, because we are facing some debates and also cases on the issue of using generative AI to infringe other people's copyright. So there's a project to do the generative AI copyright issue evaluation. So they design benchmarks by themselves and also design some kind of attack methods. They will do experiments to see whether the generative AI providers in China have provided several or have taken several measures to deal with the copyright infringement issue. And China has also developed our own large language models for the world rule of law, and this is the name of the model. And during the development of the model, we designed this kind of activity to both beneficial to the students who would like to participate in the development of the legal large language model, and also for the students who would like to use the models to assist their studies. We will provide the models to the group of students who are interested in the legal services to the companies which would like to read their businesses abroad, or they have some needs to know about the legal system and also the answer to their questions about that. So we provided these kind of big models to the students during their services, their volunteer social services to the company. And during their services, they have collected interesting questions, and they try to use the large language model to answer the questions, and they will check the answer under the guidance of the teachers and the directors of them, and they will modify the answers to bring a higher quality answer to the companies. And then they will provide the question answer data to the training of the large language models at university. So we think based on this kind of experiments of, let's say, explorations of combining the technology during the education of students, we think we may provide students more chances to learn better how to both develop the legal LLMs and also to better use them to provide services to people who haven't. So in conclusion, we think it's very beneficial to combine both the legal technology teaching with the digital law teaching. So they have always think that about AI and law, we will have two main parts, two main kinds of issues. One is AI for law, that is to use AI technologies to support the legal study, the legal issue, to deal with the legal issues, and also the law for AI, which is to study how to better develop our rule of law to let us have a more beneficial artificial intelligence services in the society. So based on that, we will also provide students the legal technology teaching from the viewpoint of from the aspects of the AI for law, as well as the digital law teaching from the aspect of the law for AI. So we hope they can combine the knowledges they learn together to, have both to have better understanding and abilities in both areas. So that is so much for the speak today, and thank you so much. Here's my email, and I'd love to receive any questions or comments or suggestions from you. Thank you.
Thank you, Professor Zhang, and thank you, Professor Li, for helping us putting this together, and also Gabriela was in charge of. So I think we can move for the next speaker that I think is Fabiano. If you are ready.
Okay, I'm ready, Professor Oscar Vilhena Vieira.
So thank you, Fabiano. We are not a protocol group, so we were eager to hear you.
Okay. Thank you so much. It's such a nice opportunity to be here with you. I listened with attention the speakers from China, our colleagues, and for me it's a privilege to be here with you today. I have to say, just to acknowledge that I come from a state university in Brazil, at the southernmost part of Brazil, Porto Alegre, Rio Grande do Sul, the Federal University of Rio Grande do Sul. And I mention this because you know that in Brazil we have the private law schools or the private universities and the state universities. And this has a difference in which we can implement the measures, especially the measures of changing curriculum and introducing digital law in our case, and especially new techniques for professors, for teachers concerning artificial intelligence. So I have to say that in my reality, things get slower, okay? And to change the curriculum. We have last year implemented new subjects in our law school for digital law. So I am the person who will be responsible in the first semester of the next year in our law school in Porto Alegre for digital law, and I was very pleased to hear you on this matter because it helped me a lot to think about the issues. I've been telling the students and colleagues that we are actually privileged. We have a privilege to be live in this transformation of new laws. It's very new in Brazil, the data protection law from the year of 2018, and we are discussing in Parliament a artificial intelligence regulation. And this is one point I'd like to address, because we still don't have the legal framework of artificial intelligence in Brazil. And also we are very much inspired of the European fundamental rights view of law in this matter. We've been inspired in this matter in data protection law, and in the law proposal that we have for artificial intelligence goes in the same way. And I question if we shouldn't be open also for other possibilities and models. I have to tell you that things go slower with us in the state university in Brazil, but I had the privilege also yesterday to finish a course for professors in my university, not only for law, but different areas for artificial intelligence. So our professors from computer science, they gave us a 3-week, actually 5 days in 3 weeks, a course for implementing artificial intelligence in our methods. And I think this should be a start, at least for Brazil, because we cannot speak about that. We cannot train our students if we, professors, don't have a minimum of knowledge how it works, how we can implement in our tasks. We are not only, actually, we are not only professors with students, we are researchers also. We have administrative challenges, especially in a state university, and we can use it, and we should use it always more, this tools of artificial intelligence. One thing also to consider, I think we should have also a union of law schools, at least law schools, discussing these methods is in Brazil. How can we improve? And I think FGV, USP, URGS, and all of PUC, the Catholic University in Brazil, they all should get together and discuss this, because I haven't seen, it can be that I'm not aware of these movements, but I think that this should be very, very useful for all of us in Brazil and connecting with our friends in China, because I'm seeing here how much ahead you are in your practice, in your discussions, in your thinkings. We have the reality, known reality in Brazil, this should be said here, that we have over 1,200 law schools. If someone of the colleagues here have this number better than I, but I know it's over 1,200 law schools in Brazil. If I'm not wrong, China doesn't have 200 law schools. And all the law schools in Brazil altogether, they're more than the world. If we would take all the law schools in the entire world, wouldn't match our number in Brazil. So that's also something to think of, because we have different levels of law schools. We don't have an uniformity in this field that we can say that we reach with our students, and all students want the same goal when they study law. I think also that what should be required then from our students is ethical and critical thinking. I think artificial intelligence won't replace it. So we have to train them. We have to train their interaction, their thinking, their reasoning with dealing with algorithm bias, ensuring transparency, and tackling the moral dilemmas inherent in automated decision making. This is something that we already have from the data protection law, and that should be even more emphasized in the not only the future but the presence of artificial intelligence. Also, and I had this opportunity to experience with the other professors from different areas, this interdisciplinary fluency. I think lawyers, judges, and legal careers must be able to fluently collaborate with data scientists, engineers, and ethicists. We should also integrate this different possibilities of one student from law taking a semester or two with some groups of engineers, of some groups of the computer science professors and students. We should integrate it even more. I think this would be very good for us. And also the high touch strategy. Also, this will keep this mastering, the strategic advisory, the complex negotiation. I think in this area, artificial intelligence can help us, but we will always need our brains to get this this sensible, defined thinking and helping our clients and the judges, helping the system to solve the hard cases. So I was told my time was 8 minutes, so I don't want to go further beyond this. But what I wanted to say in this short notice is that I believe that I've been working a lot with artificial intelligence by simulating tests, simulating working groups with my students. But I think we should, in Brazil at least, and with the help and discussion with our colleagues from China, we should improve and expand this, because I don't see much, especially in our reality of the state universities in Brazil, that this the teachers, the professors in the first place, and afterwards the students to employ in a way or in a range that I would like to see now. But I'm sure, and we have the privilege of living this, the construction of this, the construction of the legal basis. We have the pleasure of to be living this and constructing this, and that in the near future we will have artificial intelligence used for the good purposes, for the good reasoning, and helping us, lawyers, judges, attorneys, to solve the problems that society requires from us. Thank you very much.
Thank you, Professor Fabiano Menck. Now I would pass the floor to Professor Guilherme Klafke. No, Alexandre.
Yeah.
I'm sorry.
No problem at all.
Guilherme was in front of me here on the video. So, Alexandre Pacheco, please.
Good morning from Brazil to everyone joining us from different parts of the world. I'm certain that Guilherme will actually do a better job than myself, but I think it would be interesting to express that is a pleasure to take part in the second webinar, Brazil-China Law Schools Consortium. And as Professor Oscar mentioned, I am Alexandre Pacheco da Silva. I am a professor of law at São Paulo Law School here at FGV. And I serve as the coordinator of our Center for Education and Research and Innovation. And here at FGV, especially in the São Paulo Law School, I teach courses on law and technology at both undergrad and postgrad levels. And it is a truly privilege to participate in this type of events, because it's an opportunity for me to learn from different perspectives that our colleagues from Brazil and China bring to this important conversation. And before I move forward, it is worth noting the unique scale of legal education in Brazil. As Professor Fabiano Menck mentioned, our country has more than 1.4 million active lawyers, and as he mentioned, we have different estimates regarding the number of law schools, but the most recent ones, it is that we have over 1,700 law schools that offer courses in the legal market, which makes any discussion about curricula, design, and technological transformation particularly relevant and complex. I'm certain of that. And for me, exchanges like this allow us to widen our understanding of the future of legal education at a time of profound technological transformation. And to begin reflecting on the impact of technological change on law schools curricula, I think it is important to acknowledge that curricula are traditionally designed to last. This is an important thing to start here. And they should last for at least two reasons. The first one, students and faculty need curricular stability to build long-term learning trajectories. A curriculum gives structure to formation of a lawyer, and changing that structure too frequently can generate uncertainty and disrupt the coherence of legal education. Second, society and the legal profession expect universities to provide a foundation that endures beyond temporary technological trends, and a curriculum that changes every time a new tool emerges would undermine the very idea of a solid and comprehensive legal education. In Brazil, this challenge becomes even more complex because higher education regulation defines certain mandatory courses that must be included in every law program. That means only a part of the curriculum is open for institutional choice. And this leads us to the central question of my speech today. How can we use these spaces of flexibility to accommodate new topics and equip students with the skills they need in rapidly evolving technological environments? So 80 years ago, our law school undertook a major curricular reform with this concern in mind. And Professor Oscar led this process here in our school. And we reduced the number of courses students take each semester from 11 to 5. And we increased the number of hours dedicated to each course from 60 to 90. This allows for deeper engagement, more meaningful discussion, and a greater focus on complex contemporary issues. We also enhance experimental education. We expand our legal clinics, and we introduce 2 new types of courses. The first type of course that we introduced, it was our immersion format, which consists of 1 week intensive courses in which students work full-time, morning and afternoon, on pressing legal issues. The second type of course that we introduced in our curriculum was our multidisciplinary project course. 180-hour class taught by 2 professors from different legal fields, in which students must design solutions for real-world societal problems. These changes serve 2 important functions, mainly in making our curriculum more responsive. The first one is that they open real opportunities for new topics to enter the classroom, especially topics related to emerging technologies, such as AI governance, deepfake and digital evidence, crypto assets regulation, and protection of children and adolescents in online environments. That are only a few examples of the topics that we introduce in these 2 new format of courses. The second function was that these courses created spaces for professors from different areas to work together. That is a very important thing if we are thinking about a transversal type of approach. And this fostered the exchange of knowledge, created interdisciplinary collaboration, and increased the institutional incentives for faculty to engage with each other expertise. I would add a third function that for me it's the most important one. This is only my personal opinion. The third function that I think it was proved as fundamental, this reform generated institutional learning. Over the years, over the past 8 years, our faculty began debating questions we would not have been able to discuss meaningfully without this structural innovation. For example, what level of digital literacy should our students develop? Should they learn basic coding? Should we include more statistical and data literacy so they can interpret algorithm decisions with confidence? We also ask whether technology should be addressed in a standalone courses or integrated across multiple subjects. We, of course, selected the last one. These debates emerged precisely because the curriculum created the space to explore them. In other words, the reform did not focus on anticipating specific technological trends, but it focused on creating structure that allow experimentation, so that the curriculum did not need to be rewritten every time the world changed. And finally, and I'll conclude with that, I would like to return to the idea that a law school curricula should not be redesigned every time a new technology emerges. Curricula should be stable enough to support a coherent legal education, yet flexible enough to absorb meaningful change when that change has a value, a pedagogical, real value. And our reform did not make the challenge of accommodating technological transformation easier. Our faculty still engages in intense discussion about what we should do or how we should adapt. What the reform did accomplish was to give us the institutional spaces to have those conversations and to act on them when necessary. It enabled us as a law school to create the conditions for change rather than merely react to it. So with that note, I thank you very much for the attention, and it was indeed an honor to exchange ideas with all of you, and I look forward to learning from your experiences as well. Thank you.
Thank you, Alexandre, and I think there are a lot of connections among all the four presentations, and also the dilemmas are very clear posed by all of you. So I open for questions, and the questions, I think it could be first between the presenters. I think you have, thought a lot about the issues, and so if the presenters want to pose questions to each other, the floor is open. If not, then we pass to the other participants.
I could start with a very quick, direct question. One dilemma that we have in our school, and Professor Oscar knows this type of dilemma, it is about how much of technical content or technical education or courses related with technical knowledge should we introduce in a curriculum to our students? Because as I was actually seeing in the previous presentation, one thing that was important, it is that different universities use knowledge related with statistics, related with computer science, as a way to introduce the students to those topics and try to connect that topic with a legal problem or a legal issue, especially when we think about the fact that law firms, courts are using a lot, are becoming intensive in this type of technology, especially in AI. So what would be the good balance between technical knowledge and legal issues? Because as the first presenter mentioned, one of the things that is very interesting about the fact that we need our students need to make choices. It is the fact that the students want to learn about the law, and if we actually introduce more or a lot of technical courses in our curriculum, we will, in a way, absorb these opportunities that the students will have to actually discuss legal issues in our curriculum. So this is the dilemma that I would like to share with our colleagues here in our panel.
Okay, since Professor Zhang I don't think she will be able to answer you, and Professor Lee previously said that he would be filling the gaps. Professor Lee or Professor Shi, if you want to address this dilemma would be great, because I'm particularly interested on that. If I have to hire engineers to take part of our faculty, or if we keep, trying to do law for lawyers with the digital component. So Professor Lee and Professor Shi, if you could address this, and Professor Fabiano also. I'm sorry.
Okay. I think Professor Shi may first, and if not, and Professor Shi. I'll do that. Before that, I'd like to add some more information relating to the topic. First of all, I agree totally of the four speakers. They're talking about the AI education, and I extremely agree that Professor Fabiano Munch mentioned that this area is an interdisciplinary field. We need more and more experts in different disciplines to take part in this, make all of us understand the technology and the law issues. And also, we need cooperatively do something to help both Brazilian students and Chinese students. And also, Alexandra mentioned that the reform for the courses, I think that is very important. Because the current world develops so fast, so if we always chase after technology, we may always lag behind. So for lawyers, for law professors, our concern is to have the framework can regulate all new phenomena. So my thinking for this kind of issue is this: we need not understand all the technology, but we should understand what is the result of that kind of technology, which means that if it can bring more and more legal issues or bring pressure to the society, then for lawyers, we need to create something within the legal framework, cope with those kind of new legal result. Sometimes we need use the current law, which is lex lata, to judge it, to regulate it. But sometimes the lex lata is not enough. So we need to have the lex ferenda. We propose some new regulations to regulate those kind of new phenomenon or new result of that. So I think this is a kind of balance. It's not always choose this or that, but for lawyers, we need to have a legal framework to cope with all the new technology and the new issues for this era. I think this probably is the right way we can do that. But sometimes we may choose more this way or sometimes more that way. But I think in China, more and more things is that if there's a new phenomenon, we hope to find the general framework. And if the general framework can be regulate the things clearly, that's the end. But if not, then new laws may introduced. As Professor Shi mentioned that we may have new laws. Before we have the new law, then we have some regulation or some ministerial documents, which can also have the general applications to regulate the things. And then we can see what happened. If this kind of rules fit the new phenomenon, if it can fit, it's okay. Then we create more and more higher level rules, not ministerial, but sometimes maybe the central government act or law. If not, then we change the regulations. I think that is a way to adapt to the new kind of situation. This is my personal thinking. I'm not quite sure if this can meet the question of Professor Alexandra Petrino de Silva. One more information I'd like to mention that in China currently there are 700 law schools or law department. So it's developed very fast, but not all the law schools have the AI courses or digital or data law courses. In CUPL this year we have two kind of courses. First, general introduction for AI. That is requirement for all the undergraduates they need to study. Secondly, that we provide some AI courses for students studied in law area. For example, in my law school, international law school, we provide international courses, and then we currently use AI technology to help the teacher and help the student to teach or study the international law. For example, in that course, we provide kind of technology map, AI map for the knowledge international law. And we also have some AI teaching assistant to help teacher and give students more assist when they study this area. So it's currently two types of the courses we provide. So just the information for your consideration. Thank you so much.
Thank you. Professor Fabiano?
Hey, I speak 1 minute. Yeah, thank you so much for your contributions here, Professor Lee, Professor Alexandre. I think this question, Professor Alexandre, is very tough. I think in my institution, Universidade Federal do Rio Grande do Sul, for decades, we teach law for other areas. So we teach basics of law for the students from economics, for business, and different courses. Why not should our law students go for at least one semester, like they come to us and study there, for example, data science? If I'm not wrong, you have at FGV this course of data science. Another thing we're doing a lot in the postgraduate, then it's another level, okay? We have been inviting co-tutors, co-orientators from the engineering, from computer science to be together with us from law school, and they co-orient. For example, I had this student who wrote a paper about anonymization. This is very technical, and it has a huge impact in data protection and also in artificial intelligence. So we do that together, and he came also for the oral test, for the final oral defense of the thesis. This was very nice. Those are good experiences. I see in arbitration, I also work with arbitration. We have a long tradition. Not many do it, but it's nice. For example, in an arbitration of construction, that an engineer comes and decides together the case with the lawyers that are there as arbitrators. So just a couple of ideas here, and I think we should integrate more in our areas. Thank you so much.
Thank you. I am concerned with the next panel since it's late in China. So I don't know if we have some last crucial question, or we can pass the floor to Professor Lee, that will be the host for the next panel.
Thank you so much, Professor Oscar Vieira. I think this the first session. It's very efficient, and there are a lot of issues. If we can discuss, I think can keep for hours. But because the time is so limited, so let's move to the second session. The second session, we have also 4 different speakers. First is Professor Wu Shenke. He's a professor at the Law School of Beijing Normal University, which has a long history university in China. And the second is the Professor He Bo. He's the director of the Internet Law Research Center at the China Academy of Information and Communication Technology. He's a PhD in law, as a senior engineer. So you can see he's both studied law and technology. So I think it's a quite fitting the topic we discussed today. And then for our Brazilian friends side, Professor Dennis Webcano from UFPA will give his point of view, and Professor Victor Henrique Pinto Edo from USP to discuss this. So because the time is so limited, may I suggest everyone have 8 minutes for present your view, and then we can have several minutes for discussion. Is that okay? Okay. So first, the floor is Professor Wu Shenkuo. The floor is yours, Professor Wu.
Yes, thank you, Professor Li.
Yep.
So, good evening and good morning in Brazil, every professor and guests. It's always excited to speak with Brazilian stakeholders. As last year I was in Brazil, and I have found that the digital issues and AI issues are very, how to say, very hot, and the stakeholders pay high attention on the digitalization and to improve the national development status. And today we are talking about the AI and legal education in the future. I'm Wu Shenkuo from Beijing Normal University, and in our university, education is a very important topic. And in our law school, we have paid high attention, and now we also put more resource for the AI and legal education. We would like to say the evolution of generative artificial intelligence has brought unprecedented transformation to legal education, and the emergence of GPT and similar applications in 2022 marked a watershed moment, indicating that AI has evolved from a supportive tool to a new intelligent entity capable of generating creative content. And this technological shift presents both challenges and opportunities for legal education. I would like to say, compared to traditional teaching models, the integration of generative AI will reshape the delivery of legal knowledge and the formation of legal thinking, and also the cultivation of legal skills. This also requires us to rethink how to effectively combine AI with legal education while mitigating potential risks. As several minutes from some professors has discussed the possibility to combine technical knowledge and legal knowledge. I would like to say, in this area, when we talk about the application of AI in legal education, we can find at least 4 important values. First, for personalized learning guidance. In fact, AI technology empowers students with instant QA solutions and personalized learning guidance. And a prime example is Hong Kong's pioneering AI-assisted teaching assistant. In fact, in 2025, the city launched its first AI tutor, deeply integrated into university curriculum, the AI tutor agent. And this intelligence system delivers precise, variable answer while teaching students effective questioning techniques and critical thinking skills. So this immersive learning experience is significantly enhanced students' self-directed learning efficiency. On the other hand, I would like to say it's also important for innovative legal research methods. Using AI to assist in literary retrieval and organization and support paper writing, the Law School of Beijing Normal University this year has launched a specialized training program to teach students how to use AI for information retrieval, literary review, and paper writing, helping teachers and students unlock new paradigms in legal research aimed at the development of artificial intelligence. And this is also a new method to attract the attention of young students to deepen their technical and legal knowledge in this area. So the result is very positive. And for the third point, I would like to say it's also important for training legal practice skills. For example, generative AI is recognizing legal education by creating immersive learning environments, Take smart legal platforms in China as an example. These systems instantly generate detailed legal advice based on user questions, allowing learners to observe real-world legal practices and understand procedural workflows. So, in this point, AI-powered simulation now extend beyond traditional courtroom steps by incorporating role-playing exercises and document drafting scenarios. This innovation overcomes resource limitations of conventional mock trial, and it also provides learners with authentic training environments that closely replicated real-world legal application skills. And this practice is especially useful for the emerging area, for example, for the space law and for the, we can say, the sea law. So AI can be a powerful instrument for the students to understand, okay, the real environment of the cases. Last but not least, it's also important for developing courses and teaching resources. We can say AI serves as a vital tool for enhancing teaching efficiency. It assists educators in creating case materials, designing teaching scenarios, and providing intelligent support for lesson preparation, significantly improving data collection efficiency and enriching classroom content. Furthermore, AI offers guidance for teaching innovation and strategy adjusts, and it can also provide diverse solutions to address the systematic challenges. So in this point, I would like to say now, at least in China, the majority of the law school and the majority of the law students pay high attention on the application of AI, and also we would like to introduce the systematic solutions in order to use better AI and at the same moment also reduce the potential risks related to bias. For example, the discrimination and basis of AI in itself. So I would like to say now in different law schools, we have at least two kinds of practice on this point. First, we try to develop a clear, layered AI usage strategy. For example, we try to establish dedicated AI usage guidelines that clearly define permitted, restricted, and prohibited scenarios. For example, it is prohibited submitting paper or assignments directly generated by AI using the false cases and legal clauses or academic sources. For example, the guard against AI illusions. And also we try to provide confidential information or try to disclose case details to AI system. And this time, in this point, we can say implement mandatory disclosure and citation standards requiring students to include AI usage indications in certain restricted scenarios. And it is also a good point or good discussion between professors and students to understand the balance between AI use and the possible so-called false result. On the other hand, the second practice in China is we try to integrate AI literacy into the curriculum. While existing policy frameworks provide guidance, effective implementation requires educational reinforcement. Institutions could establish dedicated AI and legal ethics courses or integrate AI application into existing curriculum to teach students use of AI tools for standard exploitation while rigorous or strictly verifying output accuracy. Furthermore, organizing regular seminars featuring legal technology experts and practicing attorneys could help share cutting-edge AI applications and challenges in legal practice. So, in the end, in conclusion, I would like to say, both in China and Brazil, I would like to say, AI is an important topic, not only for students but also for professors to review and reflect the research and studying method and approach in order to welcome the future digital era. Thank you very much.
Thank you, Professor Wu, thank you for your insight. Now, let's invite Professor He Bo, Director of Internet Law Research Center of the China Academy of Information and Communication Technology. The floor is yours.
Thank you for your invitation, and good morning and good evening, everyone. I'm from China Academy of Information and Communication Technology. Thanks for being here. In recent years, we have participated in the research and drafting of AI-related law and regulation in China. So today, I want to talk about how China's AI regulations are evolving towards a future that's both open and safe, particularly how we are guiding responsible AI adoption in research and education to unlock innovation while we protect our academic ecosystem. So why is everyone talking about AI regulation now? In the past 2 years, AI is profoundly reshaping our industry and life. AI systems are moving out of labs into financial, medicine, mobility, and education. With every new development, the potential benefits grow, and so does the risk. Recent data showed that a marked increase in AI-related incidents and underscoring the need for regulation. And in education, we can see AI has created also some new problems. A Nature article warned that AI tools can trick our thinking, making students feel they understand the concepts, but when they really don't, which harms real learning and critical thinking. As a key tool for AI governance, we can see the laws can help us to set clear red line and bottom line for AI development. In recent years, we have seen the jurisdiction like European Union, South Korea, Japan, and Italy, which they have a lot of the laws and regulations that shows legal governance of AI has become a common understanding and practice. And now, when we look at China, there is a comprehensive legal framework has taken shape over the past few years. Existing internet laws and regulations have laid a solid foundation for AI governance, such as the Personal Information Protection Law, the Data Security Law. On the top of this bedrock, we can see China has enacted a series of specific rules, such as generative AI, the deep synthesis, the facial recognition, and so on, with the aim to promoting both the sound development and the normative use of AI technologies. Particularly in July 2023, China released the interim measures for the administration of generative AI services. And this also is the world's first specialized legislation on generative AI, which also clarified the overall requirements for providing and using generative AI service. The universities and education institutions are in principle also required to comply with these regulations. While it also clearly states that the industries, organization, enterprise, education, and research institutions, when they developing generative AI without providing public service within China, are not subject to these measures, which means that accepting purely scientific research from the regulatory oversight. And this last month, I, along with several colleagues from Chinese universities and AI companies, including DeepSeek, Alibaba, we published an article in the Science Journal to introduce China's AI regulatory framework. This article provides a helpful way to understand China's emerging AI regulation through 6 key pillars, which can help to make a balance between the promoting openness and managing risks. The 6 pillars are the exemption for open source AI, exemption for the research and development activities across institutions, the efficiency judgment of AI-related cases by Chinese internet court, and the regulation of AI use in scientific research, ethical review, and the AI regulative sandbox. Taken together, this can be summarized as 3 characters, that is exemption, efficiency, and experimentation, which collectively create an innovation-friendly environment for AI developers. Specifically, the 4th pillar is directly related to AI and education, and also is about the topic we are talking about today. The 4th pillar is the contextualized regulation of AI in scientific research. This entails adopting a factor-specific approach based on its institution, subject, and specific circumstances to govern the use of AI in research, particularly in 2024, last year, during the amendment of Chinese degree law. There is an official draft version once absolutely regarding AI ghostwriting as academic misconduct, but this provision was deleted from the final amendment, and a more contextual approach to regulate AI in scientific is adopted by taking a more institution-specific, subject-specific, and fact-specific approach. Therefore, we can see the journals, academic associations, universities, and research institutions in China are now currently taking different stances concerning AI-involved research, ranging from completely forbidden to case-by-case evaluation and to encouragement. For example, as provided in the guideline for Code of Conduct for Responsible Research, which is issued by the Ministry of Science and Technology, which mentioned that the use of AI-generated content in scientific research should undergo verification and be disclosed. This is in the Chinese way regulated. And dear colleagues, as we see, AI is an international public good that can benefit all humanity. In July this year, China released the Global AI Governance Action Plan, which includes education. We regard education as its 13 core initiative phases, which including promoting AI-enabled innovation in education, advocating for proprietary deployment of reliable AI systems in public service, such as education, and enhancing global cooperation on AI in education. So in conclusion, I wish to state that the application of AI in legal education require both safeguard of legal governance and the drive of innovation power. Under the principle of balance the development and safety, we must ensure the security of AI application in legal practice as well as in education. At the global governance level, the initial to strengthen AI cooperation in education is creating a new possibility for the internationalization of legal education. Let's explore a new paradigm of the AI-empowered legal education together, which can safeguard the core of rule of the law while embrace the opportunity of the technological transformation and cultivating the new generation of legal talents with both legal knowledge and the technique insight. That's all my speech. Thanks for your attention.
Thank you, Professor Hebo, for your clear explanation of the 6 pillars and the future development and perspective. Thank you so much. Now, next speaker is Professor Dennis Verbicaro from UFPA. The floor is yours.
Professor Lee, I think
Yeah.
Professor Dennis wasn't able to participate, so Professor Guilherme Klafik will be join us. Okay.
Okay. Thank you.
Thank you.
Professor Guilherme.
Thank you, Professor Lee.
Right. Thank you.
Hello.
Yeah.
It's both a honor and a pleasure to be here. Professor Dennis was unable to attend here due to health issues, so I'm stepping in and participating in this webinar. It's both an honor and a pleasure to share this panel with Professor Rebu, Professor Wu Shenku, and Professor Vitor Ido, who is a long-time colleague from our center, and it's a pleasure to be with you, Vitor. So I will share some words about AI in the classroom. I will not touch or cover the theme of regulation in Brazil. It's sufficient to say that there is a bill actually in discussion right now in our Congress, and education, some activities in education are regarded as high-risk activities. So we are discussing that right now. But I want to share some notes about generative AI in the classroom and the usage and how legal professors are dealing with this challenge and also the potential benefits from the technology. So in legal education today, generative AI is no longer this future scenario. It's in our pockets and also in our browsers inside the classroom. So in Brazil, our actual current scenario is not a mature scenario of usage and application of this technology. We are actually testing and learning from it. So I am a professor here at FGV, and I would say that our way of teaching law here in Brazil is heavily text-based and exam-oriented. It's heavily task-oriented. And the way that the generative AI tools are implemented right now, they bring some challenges to these pillars of our legal education model today. So I would say that the first wave of AI adoption is not designed by law schools, but by individual students and professors, okay? And my speech draw heavily from a paper that I wrote with my colleague, Marina Pfefferbaum, about AI and education. We make three key distinctions. First distinction about supervised and unsupervised uses of AI. The second distinction is about who is using Gen AI, the faculty, students, or administration staff. And the third distinction is what Gen AI is used for: data processing, content generation, decision support. And when we combine these three distinctions, we can make a map of who, what type, and what kind of level of supervision there is in the classroom. And my first conclusion here is that most generative AI used in law schools today is student-centered content generation and largely unsupervised. So let's begin with how professors are using AI, Gen AI in Brazil, in law schools today. So professors are already using Gen AI in many concrete ways, usually without any institutional policy and within an immature governance ecosystem. So a lot of the uses are unsupervised uses by the faculty, outside the classroom, for example, to design cases, problem questions, exams, exercises, prepare lectures, prepare slides, handouts, mind maps, podcasts, or use GenAI to translate and reformat materials. For example, translate written tests to video or audio materials. The question here is that as most professors don't have an institutional policy backing then in this use, we would say that the use this use doesn't get all the potential and the benefits that it can have, and also that there is no clear list of accredited tools, no formal training, no shared quality standards between faculty in a law school. So the question here is both that there is concrete risks regarding, for example, privacy and IP, or the contents, the expert contents that's delivered in a legal school, in a law school here in Brazil, and also a problem of inequality of access, because some professors use free tools and others use paid tools, and there is a huge difference between models that are free or paid models offered by the professors. And now I want to depart from the professors and focus on the students and how students are using generative AI in classroom nowadays. And I think that the most important reality here is the unsupervised student uses of Gen AI. I will give 4 examples. First, the problem of ghostwriting of written assignments and the question of how students are using Gen AI to write final papers, memos, theses. Here, even in our school, this is a very important challenge that we are facing right now, how to catch and also deal with these theses that are made using Gen AI. The students are using Gen AI to solve exercises and problems that professors offer as homework, for example, or even inside the classroom. They are using the AI tools to prepare for the classes. So they are, for example, transforming written texts that professors say that they should read for the class in podcasts and brief podcasts to listen to the main ideas of the texts instead of read the texts. And also they use the AI tools to participate, to help them to participate inside the classroom. For example, to formulate a question or to answer a question made by the professor. And these 4 uses, these 4 unsupervised uses of the AI tools by the students, they pose a very, very challenging question for the learning environment right now. That's how can we assess learning? How can we assess that the students are learning if our main tools to assess that are heavily dependent on tasks, written assignments, and oral participation? And all of these can be cheated by the use of AI tools. So what we suggest here at our school is to use these AI tools in a supervised manner. How can we propose that? By aligning professors and students together in an pedagogical-oriented way of use these tools. For example, students and professors can co-create learning artifacts. For example, they can co-create podcasts, comparative tables, mind maps. There is a professor here at our school, Renata Steiner, that create cases, even in other centuries, cases from other centers, and she uses the AI tool to create the scenario, the photos, the memos, the inquired documents that the students will use to answer a assessment, for example. Gen AI can be a Socratic partner used by the professor in a debate to make questions and to answer questions posed by the students in a Socratic manner. Gen AI can be a character in a role play activity. You can use the Gen AI tool, for example, a chatbot, to interact with students in a role that the student can see as a fidedigno role, as a very real player that they can interact with. So we use Gen AI to help simulations, or even to give feedbacks, or to be like a committee, assessment committee of answers that the students can offer. So I go to my final parts of the presentation, showing promises and risks of these AI tools. I think that the AI tools can be more inclusive and give personalized learning. They can help teachers to be more efficient, and they can provide richer data for the preparation of students to the classroom. But there are a lot of risks, like hallucinations, bias, inequality, even for the students, threats to academic freedom, and which kinds of materials are fed inside this model or not fed inside this model. And there are have impacts on students' autonomy and personalities, especially in self-esteem and confidence to give answers without these tools. And what we see right now are three main approaches by the institutions to this problem. First is a prohibition policy. Some institutions are trying to prohibit the use of these AI tools. The second is a laissez-faire approach, where the institution make the professor free to choose if they want to use or not these tools, and then a regulated integration of these tools inside the curriculum, as we saw in the first panel. So I want to thank you all once again, and I'm free to answer any questions that you have. Thank you.
Thank you, Professor Gulielmi Kalafuki. Yeah, yes, in every age, we can find some students they are stimulated by study, and some students they eager or they are clean to cheating. Even without AI, they may also copy something. So that is the common issue. But I think for AI age, it's quite easy for students use the generative AI tools to do that. So we need to find something to encourage them do something right, not to cheating, which is not good for their future development. Thank you so much. So next speaker is Victor Henrique Pinto Edo from USP. The floor is yours. Yeah, Professor Edo.
Great. Thank you so much. I hope you can hear me. Thank you, Professor Lee, for this presentation. It's also a big pleasure and an honor to be here with you all, especially to see some good friends and colleagues, and particularly thank you to my colleagues from FGV for inviting me. As I'm representing the University of Sao Paulo here. Oh, I hear you. Maybe you cannot hear me so well. Yeah. Can you please confirm? Yeah. If it's not so good. Yeah. Okay. Thank you. Great. So coming from the University of Sao Paulo's law school, which is about to celebrate its 200 years, meaning it's also probably not as innovative as our colleagues from FGV. It's the oldest in the country. I wanted to be very brief and basically focus on two main aspects. One relates to inequality in the use of artificial intelligence at university and abroad. And also a second point regarding the regulation of copyright-related issues on this use in the classroom. So there's many other things that could be said, of course. I think Professor Klefke's presentation already gave an excellent overview, so I'm going to focus on these 2 points. So starting with the issues pertaining to inequality. So we're a very big law school, 460 students per year, plus over 200 master's and PhD candidates as part of the current cohort. Additionally, the University of São Paulo, as well as other public universities in Brazil, has changed quite significantly in terms of who are the students. And that comes with affirmative actions, which means that now we have a much more diverse cohort of students, many more Black students, a few indigenous students, and especially we have a lot of low-income students. That means that there are many new potentials, and it's really amazing to see what's taking place at the university. But at the same time, given that the utilization of AI tools has been widespread, although not formally implemented by the university anyway, we just have a commission report. We're about to enact maybe some internal guidance on the use of AI, but not really proper regulation. One of the main issues that we are currently facing is exactly which kind of AI tools are the students using. And we do start seeing an inequality that I wanted to bring to this discussion, because while some students might have access to more advanced forms of AI tools, particularly those who have, for instance, families in the legal field, and then they might have access to very advanced legal AI tools coming from law firms or from the judiciary in Brazil that use it in a widespread manner. On the other hand, those other students were probably just going to be using ChatGPT free version or DeepSeek, of course. That poses a particularly important challenge, because the general landscape is defined by lack of regulation. There were many potentials with the use of AI. I have, for instance, conducted my own PhD studies on China. I am not really well versed in Chinese language, unfortunately, but of course, automated tools have been very useful for my own research. And this is a very obvious dimension wherein students can utilize AI tools to lower this gap between lower income students and those that are coming from more privileged backgrounds. However, when we look at the ways this has been used, and a lot has been taking place with writing, a lot with research as well. I'm not going to repeat what the others have already said, but I guess one of the main core discussions we can have between Brazil and China is exactly how to address that sort of inequality issues. Of course, one of them might refer to how universities may grant access to better AI tools. So not just about literacy and guidance, but also granting them access to some of these novel tools. So at least the utilization of these tools is the same, regardless of where you're coming from, what your family background is. Very briefly, I just wanted to mention that in the meantime, however, there's a lot of exciting student-led initiatives at the university that I think might be relevant for this discussion. We have held a few courses. It feels very different, of course, to reflect on what the University of São Paulo has been doing in its courses. We have not integrated formally an AI course or anything along these lines, but there's a lot of discussions on AI regulation. But as I said, I think particular emphasis could be made on student-led initiatives that have been focusing, among other things, on legal texts and on trying to unleash the potentials of AI more generally to the legal community. And I think that's also a different form of introducing AI in the classroom. So not in the formal classrooms, but in the interactions between the students and some of those student-led initiatives that sometimes might be partnering with law firms and other institutions. In fact, that was one of my main questions for the previous panel, which was exactly how we're going to be addressing a second major regulatory issue with this, which is how to properly balance conflict of interest rules and the novel partnerships between universities and private firms in the use of AI for classrooms. I'd like now to focus on the second part of my presentation. I promise I'll stick to the 8 minutes that have been allocated, which refers to the impact of copyright regulation in Brazil, both in terms of using it or misusing AI in the classroom. And of course, here we do have a few similarities with China, but also many, many different regulatory issues. My argument would basically be that current Brazilian copyright law is in many ways unsuited, both to address the risks, to safeguard the protection for right holders, but also on the other hand, to properly adequate promote the use of generative AI in the classroom. So starting with how it does not sufficiently safeguard protection for rights holders or address some of the risks. I guess the main concern in Brazil, which is part, of course, of a global trend, and in the case of our country, is particularly related to issues of misappropriation and concerns of market power by large platforms, not just AI platforms, but of course they're part of the deal, relates to the free appropriation and free utilization of copyrighted material for the training of AI. But I just wanted to share with our Chinese colleagues maybe two particularities of Brazil's regulation. I guess one relates not only to sensitivities of personal data, but also to minorities' communal data. I'm specifically referring to the utilization of indigenous related content for the training of AI. And indigenous peoples are afforded special protection under Brazilian constitution, as well as Afro-Brazilian people of African descent and some other minorities. And of course, a lot of emphasis in regulatory discussions in Brazil on gender and African-related content as well. So that just means that apart from larger copyright issues, there's also these bias touches that are basically adding to the complexity of the issue. I also just wanted to share one interesting case we had in Brazil where a amusement park utilized an AI-generated song, if we want to call it a song, and there's not clarity under Brazilian copyright law whether that is protected under copyright. So that means maybe it was just, you know, some music, but it's not really protected by copyrights, but still Brazilian collecting society charge royalties on this. So I guess that just presents how much this legal uncertainty has impacting regulation in Brazil more broadly. But I just wanted to conclude with the other part of this discussion, which is how our copyright bill does not really have a clear exception or limitation for educational purposes nor research. That is thankfully the case in China, but that means in the case of Brazil, a little bit less for professors who will still probably be sharing materials, and there's some case law that will be allowing them to do so. But it does become a little bit more uncertain for institutions to formally adopt AI conducive policies in classrooms because, among other things, of copyright risks. So with this general framing, what I basically wanted to say and to mention to all of you, of course, Brazil is negotiating the approval of a general AI bill, as well as reforms to its competition law. And generally speaking, we're in this process of developing a better framework so that both the uses in classrooms that can be conducive for better training for legal education and also to address risks, hopefully will be addressed in the upcoming years. I'll finalize by saying that inequality and copyright-related issues are actually completely intertwined in the case of Brazil, in my view. And I would just finalize with some word on how addressing unequal access to technology is as important in Brazil as it is to better understand how AI operates. So I'll stop there. Thank you very much again for this opportunity. It's been tremendously positive, and thank you so much.
Thank you, Professor Victor Idle. Thank you for your insight on the generative tools used for education and also the cutting-edge issue for copyright. Yes, copyright, usually copyright is protected for the expression, but not the idea. But it looks like currently the generative AI tools, they create the expression, and the idea is provided by a human being. So it's really a kind of a challenge for the copyright issues. I think that kind of case may happen more and more, not only in Brazil, but also in China in the future. So we have the full speakers all deliver their presentation and lectures. And I'm sorry to say that Professor He Bo, he got an urgent call, long distance call, so he's not here. But now let's have 4 minutes for discussion. Also follow Professor Oscar Vera's style. First, the panels. Yeah, panelists, your discussion within the panels or your questions. Professor Wu, Professor Victor Edo, and the Professor Klafki. Yeah. Do you have any questions to discuss first?
Yes, I would like to say, when we use AI to improve our legal education, it is important to have the values as center for the whole program. And in Brazil, I would like to understand, in Brazil, what will be the core target for the application of AI in the area of legal education? Thank you.
Who will answer this question?
Yes.
Yeah.
Professor Lee, I would highlight a comment that Professor Vitor made about this inequality of access. I think it's important, both for our two countries, Brazil and China, to discuss also the inequality of data access and data offered to these models, because actually it's important to think on how can we develop models that are based on our contexts in our materials, and so that we will not have like answers that are homogeneous or that are or impose like a worldview that's made by the data or the materials that are provided or inputted in these models by other companies. So I think this is a major issue here in Brazil. I don't know if Vitor wants to share some comments about that, but I would say not about just the inequality of access by the students, but also the inequality of data and materials that we provided to these platforms.
Yeah, thank you, Professor Klafka. And Victor Edo, yeah, Professor Victor Edo.
No, thank you. I was just going to fully agree. And I think broader issues of inequality are always part of Brazilian discussions, but they're really global issues. I would add, however, that both copyright barriers, but also lack of pluralism that has been generated by some platform domination by some companies here in Brazil have become subject to particular scrutiny. And our competition commission, for instance, is about to decide in a few days whether they're going to be relaunching a discussion on journalism-related AI issues, and that basically not going to go into the details. It's part of cases that have been launched in other jurisdictions as well. But in the case of Brazil, just like in South Africa, it is very important to focus on media pluralism in that case. And I think that is also part of our discussion. So I think to answer Professor Wu's remarks, I think it's true that Brazil's emphasis on AI regulation will be somewhat different to China, partly because we don't have such a general framework as of now. But I do believe that it would be important for Brazil nonetheless to focus a lot on those broader inequality issues, both from access to technologies and, as Professor Guilherme said, also in terms of the data and what is being available to the students. I'll stop there. Thank you.
Yeah, thank you, Professor Victor Edo. Any other speakers would like to ask question or comments? If not, I'd like to add one kind of information relating to the generative AI tools. When I studied in law school as a student, I usually take the examination from my professor that face-to-face talk. So, which means that he or she will know exactly what you understand the issue directly. So it's an old-fashioned way for examination, but it's very efficient. He or she can quickly evaluate what you're learning, your knowledge, and your further thinking of this issue. But for undergraduate student, I think it's impossible because there are a lot of students there. For master or PhD, probably that is the one way. So it looks like in the AI age, if we want to prevent cheating, we can go back to the old-fashioned way to resolve those kind of problem. Of course, there's also another way that currently there's a kind of AI tool can recheck the paper students present. It can easily to see if it's AI generated paper. So it's a kind of a technology way for using of this. But I agree all your presentation that the most important thing is the value. Go back to encourage students study, and that is the way for education, not to use the AI tool to give a very short way, but that is can probably in the future is an obstacle for their life development. So thank you so much. I think this is the end of the second session. Professor Oscar Werner, would you like to presiding the close ceremony?
Is Professor Shi still here?
I think he's here. 石老师，您的那个话筒没打开。石笑，你话筒没打开。石笑，你的话筒没打开。
Okay, so all right, so if we are still waiting for him, I would like to thank all the participants. I think this has been quite of an experience since the first encounter in Brasilia last year in the conference where this consortium was founded. I think it's extremely important initiative that was bring together by Justice Herman Benjamin, the partners in China, and a large group of universities also in Brazil. I think Brazil has a lot to gain with this partnership. I hope the Chinese also do see advantage in keeping this initiative moving forward. Our first presential conference draw two basic issues that perhaps would be of mutual interest, both on climate change, biodiversity, and the issues regarding environmental law. And now we are talking, we also discussed in Brazil, and this reflects on this second webinar, the issue of artificial intelligence, the issues of digital law. And I think perhaps we should be refining our agenda for the next presential meeting that perhaps would take place in China this next year. So I really appreciate the efforts of all of you that organized these two webinars. Maria Lucia from our side. I will thank Professor Li, who's here from the Chinese side, and think that we should, as soon as possible, start to organize the next conference in China. Thank you very much for being here, and I hope Professor Shi had the time to arrive to say the last and final words. If not, I pass the floor to Professor Li.
Okay, thank you, Professor Oscar Vera. Thank you so much. I also have a lot of things to say, but you know, it's very late in China. First, I'd like to thank all of you, especially Prof. Antonio Benjamin. He and Professor Shi, they launching this kind of cooperation platform, and then we can have this chance for discuss the important issues last time and this time, and also in Brazil and next year in China. I think that is a very good start point for Professor Shi and Chief Justice Benjamin, and all the professors, especially Professor Oscar Vera. You organize 2 times of the webinar and ask all of our excellent colleagues from Brazilian side to participate in this kind of useful and meaningful discussion. It's past almost 1 hour according to our schedule, which means that this topic, we choose this topic, is very important and very interesting. We are, we spend more time, but I think we're all very interested in this issue, and the discussion is fruitful. Thank you for all our speakers for your fruitful contributions, and make our this evening and this morning so interesting in our life on Earth. I think that in the future we can have more and more corporations. It make me think about this kind of suggestion. If I'm not quite sure if it's possible or feasible, that I think that some of the courses may benefit both you and our students. So if in the future, if you have some courses you think can provide to our students, or our courses can provide to your students, we can probably incorporate those kind of online course, but we need to adjust the time to make both sides can enjoy it, not too late or too early in the morning or in the night. Thank you so much. Thank you so much. I really are looking forward to have another kind of conference. Thank you. Yeah.
Thank you. Thank you. It
Yeah.
was a pleasure.